Alan Dershowitz sat in the Harvard Law School auditorium, adjusting his reading glasses, the 86-year-old legal scholar and former appellate attorney preparing to challenge a congresswoman he had dismissed in previous media appearances as representing the inexperienced progressive wing, whose policy positions reflected emotional appeals rather than serious legal or constitutional analysis. The legendary attorney, who had spent 6 decades building reputation as one of America's foremost constitutional experts through Supreme Court victories, best-selling books, and high-profile celebrity defenses, had apparently decided that this law school symposium on constitutional interpretation would provide the perfect forum to demonstrate his intellectual superiority by challenging someone he assumed could not match his credentials or his command of constitutional doctrine. What transpired over the next 22 minutes would expose how completely his assumptions were wrong and how catastrophically he had miscalculated in attempting to lecture someone whose preparation and knowledge would systematically dismantle his arguments while revealing that his celebrated constitutional expertise was contradicted by his own inconsistent positions and selective use of precedent. Jasmine Crockett had walked into this Harvard symposium, having spent weeks reviewing every constitutional argument Dershowitz had made throughout his career. Having identified clear patterns where his legal analysis served his political preferences rather than following consistent methodology, and having prepared evidence that would use his own previous statements and legal positions to prove that he either did not understand or deliberately misrepresented the constitutional principles he claimed to defend. When Dershowitz opened by challenging her support for expansive federal social programs as reflecting constitutional ignorance and suggesting that someone with her limited legal pedigree could not possibly understand the nuanced constitutional questions that someone with his Harvard credentials and Supreme Court experience had mastered, her response presenting side-by-side comparisons of his contradictory constitutional arguments on presidential power, executive privilege, and federal authority depending on which president he was defending, would leave him frozen at the podium, unable to explain why his constitutional principles changed based on partisan loyalties. Before we show you exactly how Congresswoman Crockett used Dershowitz's own legal writings and court briefs to demonstrate that his constitutional analysis lacked the consistency and rigor he claimed to embody, while simultaneously proving that her understanding of doctrine was more thorough and honest than his selective quotation and motivated reasoning, make sure to hit that like button and subscribe so you never miss these extraordinary moments when genuine constitutional knowledge built through practice exposes the intellectual dishonesty of those who trade on reputation while making arguments contradicted by their own previous positions. The Harvard Law School Symposium had been organized to examine competing approaches to constitutional interpretation and to facilitate dialogue between scholars, practitioners, and policymakers about how constitutional principles should inform contemporary governance. The symposium had attracted prominent legal figures representing various interpretive methodologies, including originalism, living constitutionalism, textualism, and pragmatism. Dershowitz had been invited as someone whose constitutional scholarship and litigation experience gave him authority to speak about how courts should interpret foundational legal texts, while Crockett had been included as a practitioner whose civil rights work and congressional service provided perspective on how constitutional doctrine actually affected people's lives and rights. The symposium had proceeded through its morning sessions with various speakers presenting their approaches to constitutional questions, ranging from separation of powers to individual rights to federalism. Dershowitz had delivered a presentation emphasizing that his constitutional methodology was based on careful textual analysis, historical understanding of framers' intent, and consistent application of principles regardless of political consequences. He had positioned himself as someone whose constitutional analysis transcended partisan politics, and who applied the same rigorous standards to evaluating government action regardless of which party held power. When the question and discussion period arrived, Dershowitz had directed comments to Crockett, suggesting that her support for expansive federal social programs and robust civil rights enforcement reflected inadequate understanding of constitutional limits on federal power and insufficient appreciation for the framers' design of limited government with carefully enumerated powers. He had noted with apparent concern that politicians who had not studied constitutional law at elite institutions or who had not argued constitutional cases before appellate courts often misunderstood fundamental principles and advocated for policies that exceeded constitutional authority. His comments were delivered with the patronizing tone of professor correcting students' basic misunderstanding, and they positioned him as the constitutional expert who would explain to her why her policy positions were constitutionally problematic. He had clearly expected that his credentials and his framing of the issues would put her on the defensive and would create opportunity for him to demonstrate his superior knowledge before the Harvard audience. Crockett thanked Professor Dershowitz for raising questions about constitutional interpretation because she believed these were among the most important issues facing legal scholars and policymakers. She noted that he had suggested that her positions reflected constitutional ignorance and that his own analysis represented rigorous application of consistent principles. She stated that she wanted to examine whether his claim to principled constitutional analysis was supported by his actual record or whether it was contradicted by patterns of inconsistency that revealed political rather than legal reasoning. She began by noting that Dershowitz had been prominent defender of expansive presidential power during Trump administration, arguing that presidents had broad authority that could not be constrained by Congress or courts, and that impeachment required proof of criminal conduct. She cited his specific arguments during Trump's impeachment proceedings, where he had claimed that abuse of power was not impeachable offense, and that presidents had nearly unlimited authority to take actions they believed served national interest. She then displayed side-by-side comparisons showing Dershowitz's dramatically different positions on presidential power during Clinton administration, when he had argued that presidents could be impeached for abuse of power even without criminal conduct, and that Congress had broad authority to constrain presidential actions. The comparison showed that his constitutional analysis of presidential power had reversed completely based on which president was being evaluated. Crockett noted that someone claiming to apply consistent constitutional principles should have reached similar conclusions about presidential power, regardless of whether the president was Democrat or Republican, and that his contradictory positions revealed that his constitutional analysis served political preferences rather than following principled methodology. She asked him directly to explain what constitutional principle justified his opposite conclusions about presidential power and impeachment depending on which party held the White House. Dershowitz attempted to respond that the constitutional questions in Clinton and Trump cases were different, and that his analysis had appropriately addressed different factual circumstances. However, Crockett immediately displayed additional evidence showing that he had made sweeping statements about presidential power and impeachment standards that contradicted each other and that could not be reconciled based on factual differences between cases. She proceeded to address his arguments about executive privilege, showing that during Obama administration he had argued that executive privilege was limited and could not shield wrongdoing, while during Trump administration he had argued that executive privilege was broad and that courts should defer to presidential claims. She noted that his constitutional analysis of the same constitutional provision had changed dramatically based on which president was asserting it. The Congresswoman then addressed his arguments about federal power and constitutional limits on government action. She noted that he had argued in some contexts that federal power under Commerce Clause and spending power was limited, and that social programs exceeded constitutional authority, but that in other contexts involving policies he supported, he had argued for broad federal power. She displayed examples of him arguing for expansive federal civil rights enforcement when it aligned with his priorities, while simultaneously arguing against federal social programs using constitutional objections he did not apply consistently. Crockett stated that the pattern across these examples was that Dershowitz's constitutional analysis expanded or contracted federal power, presidential authority, and individual rights based on whether the results served outcomes he preferred politically. She noted that this selective constitutionalism was not principled legal analysis, but was rather using constitutional rhetoric to advance political agenda while claiming neutral expertise. She then delivered the most devastating portion of her presentation by noting that she had reviewed Supreme Court precedent on the constitutional questions Dershowitz had addressed in his various arguments, and that binding precedent consistently contradicted the positions he had taken when those positions served his political preferences. She cited specific Supreme Court cases, establishing that presidential power was not unlimited as he had claimed during Trump impeachment, that abuse of power was impeachable, as Clinton-era Dershowitz had argued, but Trump-era Dershowitz had denied, and that federal spending power was broad, as she had argued, but as Dershowitz sometimes claimed it was not. She observed that his constitutional arguments often ignored binding Supreme Court precedent that contradicted his preferred conclusions, and that his claim to rigorous legal analysis was undermined by his pattern of selectively citing cases that supported his positions while ignoring contrary authority. She stated that this approach was advocacy rather than scholarship, and that it was intellectually dishonest to present politically motivated legal arguments as neutral constitutional analysis. Crockett concluded by addressing his suggestion that her lack of elite credentials limited her constitutional understanding. She noted that she had practiced constitutional law in federal courts, where judges evaluated arguments based on their legal merit rather than on advocates' educational pedigree, and that this experience had taught her to build arguments on binding precedent and consistent methodology rather than on selective quotation and credential-based assertions of authority. She stated that Dershowitz's record showed that Harvard degree and Supreme Court experience did not guarantee intellectually honest constitutional analysis, and that his contradictory positions on fundamental constitutional questions revealed that his analysis served political loyalties rather than legal principles. She observed that she would prefer constitutionally sound arguments from any source over politically motivated arguments from celebrated scholars, and that examining actual records rather than accepting credential-based claims of expertise was essential for evaluating constitutional discourse. The Harvard auditorium fell into stunned silence as Crockett concluded. Dershowitz sat frozen at his position, his face showing visible shock that someone had comprehensively documented his inconsistent constitutional positions and had presented the evidence in systematic way that he could not easily dismiss. The audience of law students, faculty, and practitioners recognized that they had witnessed thorough dismantling of celebrated scholars' credibility using his own contradictory statements as evidence. Dershowitz attempted to respond, but his answer was notably defensive and evasive. He suggested that cherry-picking positions from decades of writing ignored context and evolution of his thinking. However, Crockett's presentation had not involved isolated quotes, but rather had shown systematic patterns of contradiction on fundamental constitutional principles that could not be explained as intellectual evolution, when the positions oscillated based on which political party benefited. The story of Alan Dershowitz challenging Jasmine Crockett, only to be left frozen by her evidence of his contradictory constitutional positions, became a defining example of why credentials alone could not substitute for intellectual consistency, and why examining actual records was essential for evaluating claims of expertise. If you found this valuable, please like this video and subscribe to our channel.